Ready to go?
Yes.
You may call the next case, please.
John Jason Moore versus Amanda Jean Heilbrunn.
Good afternoon, Your Honors. Casey Long of the Lawrence County Bar. I would like to reserve 5 minutes for rebuttal, Your Honor.
5 minutes?
Yes, Your Honor.
All right, sir, you may proceed.
Thank you, Your Honor. This matter originated in the Juvenile Court of Lincoln County, Tennessee, in perhaps not unique, but definitely somewhat strange circumstances. It was ostensibly somewhat initiated by the filing of an order of protection by the appellant against the appellee. Subsequently, at that hearing, the trial court came to the decision that the appellant would be required to take a drug screen. A drug screen was taken. That drug screen indicated the presence of illicit substances. And as a result of that, there was an agreement announced to the court that was ostensibly an agreement in regards to paternity and an agreement in regards to custody of minor child Stella. Immediately, or almost immediately, after that announcement was made, the appellant went out and got independent drug screens. Independent urine screen, independent hair follicle screen, and subsequently came back to court shortly thereafter on a motion to reconsider custody award or in the alternative for return of custody, which is somewhat of a different animal as well. And the court, in its hearing, made a determination that it would proceed both under a Rule 60 analysis to determine if the matter should be set aside based under any of the 60.02 factors, or if the case would go forward as a modification or change in custody matter. There was some discussion in regards to that amongst the parties and the court indicated that it would proceed under both analysis.
Let me ask you a question.
Yes, Your Honor.
A couple of questions here.
I anticipated many, Your Honor.
Well, I have several. Is the order that changed the custody, the December 20 order, is there a December 20 order?
There is a December 20 announcement that was later reduced to an order.
Is that in the record?
I believe that it was, Your Honor. It's my recollection that it was.
Okay. Do you know when that order was entered?
Your Honor,
I
did not bring, it was definitely in between that announcement and the February 23rd hearing, Your Honor.
All I can say is when I looked at it, it wasn't in the record. Now, it may have been added later, but, so, was that an agreement, or was that?
It was announced as an agreement, Your Honor, yes.
Okay, based upon the drug screens, I'm assuming. Yes,
Your Honor, and as sort of a background to kind of explain that, which Your Honors may or may not want, the appellant had 2 other children of her own in her home, and I believe there was a concern that the Department of Children's Services might become involved if this agreement was not reached.
Okay.
Which may provide a missing puzzle piece for the court in understanding why this occurred.
Here's my first concern. The trial court, and apparently the parties, approached this as one of 2 avenues, a Rule 60 relief or motion to change custody. If no order was ever entered, I don't know how you determine which is the correct avenue. I'm fairly comfortable it's not Rule 60 because Rule 60 is relief from a final judgment. It may be a Rule 59 motion to alter or amend. It may not be anything if there's no order that was ever entered. So that's where my initial
Well, and Your Honor, now, a different argument springs forth for me now based upon Your Honor's questioning is if it's this court's determination that that order was not in existence at the time of the February.
I don't know that.
Well,
I
I understand.
I'm just, that's why I'm trying to find out.
If it was not in existence at that time, then the court, in order to reach its permanent parenting plan, would have to perform the analysis required to create a permanent parenting plan, which also was not present in this case, and also would be, the appellant's opinion, a great reason to remand it for a full hearing and for the court to make its determination based on all the relevant factors.
Let me ask you what perhaps is a simpler question. What analysis did the trial court perform at its subsequent hearing in, I believe, February?
Your Honor, our argument is essentially none, based upon the ruling, because now I'm going to argue it two different ways. If an order was in existence and the court was called upon to determine whether there was a material change in circumstances, and if a material change in circumstances was found, then called upon to modify the permanent parenting plan. It clearly made a modification, at least in its own eyes, from what was announced in December of 2022. It gave the mother visitation that was not present in that announcement. If the court made a modification, vis-a-vis, it had to have found that there was a material change in circumstance. And I have to engage in a lot of guesswork and conjecture, which is, from the wide and vast body of the case law, is exactly what the appellate court does not want the trial court to do, is give us an order that requires us to engage in a lot of guesswork and conjecture. But the best guess would be the mother appearing with multiple drug screens that indicate that illicit substances were not present in her body, and arguably that a hair follicle test is even more reliable than a urine screen that was conducted by the trial court. Therefore, material change in circumstances is shown, parenting plan is modified. However, absolutely none of the factors are mentioned, weighed, or made determinations thereon.
Well, let me help you here.
Thank you, Your Honor.
Page 102 of the transcript, and I know perhaps there's some dispute about the transcript, I don't know. There is a transcript in the record. At 102, at the top of the page, because there are two different numbers on it, trial court says, all right, folks, I've heard the proof. I'm going to start with the big issue kind of at the end of the case and go backwards. But as to the custody issue, the law requires that to change custody, the party who wants to change it must prove that there's been a big change of circumstance, and secondly, that because of that big change, it would be in the child's best interest to change custody. I cannot say the burden's been met today, as custody will remain with the father. Consequently, it looks like the trial court treated this as a petition to change custody as opposed to a Rule 59 or Rule 60 motion.
In that aspect, yes, Your Honor, they absolutely did. There's no real discussion in the trial court was in a position, arguably, that it would have potentially had to go through the Rule 60 factors, 6001 through 6002.
Rule 60 is not even applicable here.
And fair enough, Your Honor.
With all due respect, you've got to have an order that became final for Rule 60 to apply.
I understand, Your Honor. I'll move on to the next point.
Or that's my opinion.
Well, and that's fine, Your Honor. You wear the robe, you get to have your opinions, and they mean more than mine.
one of three.
But, Your Honor, my main point, and because I am running out of time, my main point is that the dictate from all the cases that have preceded this is that the court is required to be as precise as possible, and as possible in making child custody findings in order to facilitate a meaningful appellate review for your honors. Not necessarily to make your job easier, but to make your job doable. And the argument in this case is the lack of findings and rulings from the trial court makes your jobs very hard, almost undoable based on some of these rulings, and leads to that guesswork and conjecture that I've spoken of. Thank you, Your Honors.
Thank you. You've got your rebuttal time.
May it please the court. Tim Underwood from the Giles County Bar. If I could, Judge Stafford, I'd like to sort of address some of the questions that I think that maybe you asked from the very
Perhaps
beginning
you
of
can
it.
bring clarity to this, Mr. Underwood.
I'm sorry, Judge.
Perhaps you can bring clarity to
Judge,
this.
I will try to bring some clarity to this to the extent that I can. I do believe that there was an order that was there. I agree with the court is that it's not part of the record. I asked that the clerk supplement the record for a couple of different things, both before and after this, and the record, it just never got there. But I think what we can look at to know that there's a final order is that there was a request, and it was an oddly, and I think we agree with that, the oddly named petition that brings us here is a motion to reconsider, or in the alternative, a return of custody. So it implies, and that even that petition or that motion that's actually in the record actually references the fact is that there was a prior custody decision that was done, and we don't disagree about the facts about how that got there. Is that the court asked both parties, not just one party, asked both parties to submit to a drug test. And maybe ask is a little misnomer. The court required both parties to do it. The appellant tested positive for that. The appellee did not test positive for it. So based upon those circumstances is the parties agreed to a change of custody. That was the December 20th, 2022 order that went down that apparently has not made it to the technical record.
And you believe there is an order?
There is an order, Judge.
But that would have been subsequent to December 2022.
It came from the there was as I understand it, the way that juvenile court operates in Lincoln County, that I was not there as a trial counsel, as I understand it is, there was an agreement that was rendered between the parties, it was presented to the judge, and then at some point later on, it was reduced to writing and then filed. I think it was sometime in January that it was actually filed, that was there. But there was a court order about that. I don't think that is in dispute with the parties is. Now, I understand the court's concern is that it may not be part of the technical record, but I don't think that part of it is actually in dispute about that.
And then this operative motion was filed, according to my notes, January 3, 2023.
That is correct.
So it could have been filed before the order was filed.
Judge, it actually was filed before the order. So it was a little, so what the court did after that, and I'm gathering it from 10,000 feet, just like this court is from the technical record perspective is that there was a subsequent hearing before the February 14th where there was even a Pendini Lighty hearing where there was some supervised visits that was granted to that. So I do believe that there is a final order that exists, and I think that's why Mr. Long had filed the Rule 60 or argued the Rule 60 motion in his brief about it is. The motion in and of itself is a unique animal, is that it's called a motion to reconsider, or in the alternative, a change of custody, or a return of custody, I think is actually how it's actually labeled. So there were some discussions at the beginning of that, and the transcript reveals that, and there was not a stenographer that was there. I actually, with the consent of Mr. Long, had the recording that had it reduced to writing so we could actually have a transcript of what happened. And at the initial part of this is the court looks at this, Judge Myrick looks at it and tries to determine what actually kind of motion this is, because it does not have any specificity. It does not indicate what the material change of circumstances is, nor does it even argue what rule of the civil procedure that they're asking for this reconsideration to be. As in regard to Rule 59, I get where Your Honor is asking that question is, we're prepared to defend it based upon a Rule 60 motion because that's seemingly what the parties thought when they were there, and that's what has been briefed under this scenario, again, assuming that there is a final order.
How can it be a Rule 60 motion?
Judge, I'm sorry?
How can it be a Rule 60
Judge,
motion?
now, I would agree with you is if you want to find that it's no Rule 60 motion is, I don't disagree with you about that is. I'm prepared to argue the second issue, which is a material change of circumstances.
Well, if it's not a Rule 60 motion, it's got to be a Rule 59 motion, because 59 deals with non-final orders, 60 deals with final orders.
The reason that I come to that it's a Rule 60 motion is because the court believed that there was a final order. I know, again, it's not in the transcript, but the court did, and the court went on to actually read the rule out loud to the parties, and everybody there agreed that this was a Rule 60 motion. So what transpired after that is, and I think this is the most material part of it, is regardless if it's a Rule 59 or a Rule 60 is, there's never any proof or there's never any argument at the trial court level as to what motion this actually is. What happens is after they go through this dialogue of, even trial counsel for the appellee, the appellee even objects to this, is saying is, well, there's no clarity to this. There's nothing in the motion. You can't have both a reconsideration and a change of custody. They have to pick one. There's sort of an election of remedies argument that's being made. And the court says, no, we're going on with both of them because of notice pleading, and we proceed. What happens after that is important is because what the appellant does is they put all of their eggs in one basket and they argue that this is a return of custody. There's never any kind of mention of Rule 60 again. There's never any mention certainly of Rule 59. And it's just simply waived. I think we cited some cases, we did cite some cases.
Why is it waived when she presented evidence of the drug test being in error?
Judge, and with all due respect to the court, is I take exception with the fact is that there was a drug test and it was error.
I'm just telling you
okay.
what I read the transcript. What she's saying is, I got this bad drug test. I went and got 2 other tests that day, and they say I'm clean. This one says I'm positive. So the court didn't rule on that.
What the court ruled on was what was actually argued in front of the court is, and that was the material change of circumstances. There was never any kind of proof that this was, for the first time in the technical record, well, there's nothing in the technical record actually that speaks to Rule 60 or Rule 59. The first time we even hear
I will give you that.
Yes.
There is not anything in it that I saw.
Yes, sir. The first time that we hear that is actually in the appellant's brief for the very first time where they argue subsection 1, which is a mistake, and then the catch-all under subsection 5. There's no other mention of that in the record at all, so that's why we would argue that it was waived. It's hard to complain about the trial court not making findings of facts, conclusions of the law as it relates to Rule 60 when there was never actually any argument that was presented to it is. And to be candid with you, it is, I think what the court tried to do at the outset is to take a motion that was very vague in what it is, encourage the appellant to define what relief they were seeking, and read the rule to them to sort of hear the subsections, present me some argument to how they apply. So that's why I would say that it was waived, because it's being presented to this court for the first time on appeal, because there's never been any mention to it is.
Well, let me try to back into it a different way.
Yes, sir.
Was there evidence submitted that the appellant believed that the initial drug screen was wrong and that 2 subsequent drug screens were taken
Judge,
and presented to the court?
I'm sorry, Judge, I think there was 1 drug screen. I think there was some reference to another one, but only 1 was actually presented. I think 1 was attached to the complaint, but nothing was ever offered in as
I know
evidence.
there was some argument about business records in here and about whether or not that information could be received by the court.
Yes, sir. So what I would say about that is, even if that is true, is the overwhelming evidence would indicate that this appellant, this mother, had a continuing drug problems, and that was what the evidence that was had. And so when we talk about a mistake, again, getting back to Rule 60.021 is, it's hard to articulate that this was a mistake. And again, when they argue mistake in their brief, I'm not sure exactly what the mistake is, because as Your Honor indicated is that she knew that the drug test, or at least in her mind, that she was negative for these drug tests. So it's hard to imagine that that is in fact a mistake if she knew it and then she went into court when she was presented with that one and didn't preserve any type of argument for the specimen being preserved, or argument with the court asking the court for a continuance, or asking the court to initiate a different particular kind of drug test. So that's where we come from, is that it's not a mistake that the trial court made. And it can't be a mistake that she has, because she always professed the fact that this was a test that she did not feel that was accurate. So that's our position on
What was the proof, if any, at the hearing in February to show that the December test was a mistake or inaccurate?
There was none. And so what was presented to this court in its brief was a comment about what the trial counsel for appellant made in opening statements. And we briefed that is that that's the only comment that was made, and opening statements are not proof. Now, it's a guidepost as to where the proof was going to be going, and much like you judges, when you read the transcript, you were waiting for that proof to come, as I read the transcript and it simply just never came. There was never any kind of proof. Arguably, is one subsequent test does not disprove the first test. That's what we argued in our brief, and I think it's important because what the overwhelming proof was at trial is that the appellant had a substantial amount of drug histories, not only in the state of Alabama, where this child was taken from her because of a fentanyl overdose, but she also had a significant drug issue in front of this court because she was on probation in the General Sessions Court for Lincoln County for the same drugs for a DUI case. She had also lost custody in juvenile court of Lincoln County in front of Judge Myrick as it relates to her other children, and what she testified is that drugs were more important to her than her actually family was. So that's what we would argue.
The initial drug test was taken when?
Do what now, Judge?
What day was the initial drug test taken?
The initial drug test was taken on 12/20, which would have been the date that they were in court. The judge administered the drug test at the courthouse that day.
And then she goes to another doctor that afternoon, correct?
I don't think it's another doctor. I think it is someone that worked in a law office. That was the hair follicle test that she got, and it may have been a day after that. And so that gets back to—
I thought there was another doctor involved in this as well.
Again, there was some issues about that in the technical record and what I would submit to you is that there was never anything that was actually established as proof in that. The only proof that was before the court about a subsequent drug test was that hair follicle test that she took. So, and again, there was proof at the February hearing is that she had previously altered a DCS drug screen to be able to avoid detection by the state of Tennessee. So I think there was overwhelming proof that this was not a false drug test. What I briefed was the anomaly may be how she ever actually got a subsequent drug test to begin with. So I don't think that subsection 1 or subsection 5 apply, even if they're not waived. The case law as it relates to subsection 5 is that litigants have to cannot be free from informed decisions that they make, and they have to take steps to protect their own particular rights if you're going to use subsection 5. And so this was ultimately an agreement that she had.
So on December 20th, you argued the court administered the drug test, but I would assume that the court didn't do that. They ordered it to be done?
As I understand it, again, the record's not completely clear about this, but I don't think there's any dispute about it. I think it's done at the courthouse. And so our position has always been is, again, the appellee took the drug test. He's not complaining about it and there was no proof in the record where there was any kind of evidence, whether that's from the clerk or the juvenile court officer, that testified that there was some kind of inherent false positive with this particular test. So there's nothing in the record that indicates that the decision that she didn't make, even if she believed that it was a false positive, there was no fraud that indicated to that. She made the decision freely and voluntarily, and she had the assistance of counsel to be able to do that. So that's where I say that Rule 60 does not apply. The second issue that sort of comes up in this case is that the appellant takes issue with the permanent parenting plan that was invoked by the court. I would say to this court is that was an act of benevolence by the juvenile court, because she never pled for a modification of the permanent parenting plan. She only pled for a modification of the custody arrangement. And so when the court found that there's no material change of circumstances, which was not appealed, by the way, that's not an issue before the court, is the court could have concluded the case at that particular point is, but the court went back and said, I'm trying to sort of help the appellant because the appellant had voluntarily given up any rights to visitation and given up any rights to custody. So the court actually entered into a permanent parenting plan that gave her more visitation than what she had ever had before. So I'm not really sure that I understand the issue that's being raised by the appellant in this particular case. For the second issue is because the objection seems to be that the court didn't consider the best interest analysis, but the court gave the appellant something that she didn't have already. So my time is up, but if there's
What about
questions.
the trial court's order? Do you think it's sufficient for us to review? Looks like
Judge-
about a half a page and a half. Okay.
Yes, sir, Judge. I think there is sufficient that's there is. I think the court went through and certainly in describing it, went on to say clearly that there was no material change of circumstances. And so if the court rules that there's no material change in circumstances, the first criteria of the two-pronged analysis is not met, and so there's no reason to do a best interest analysis. I think it's interesting to what the court said after that was, and it was a moral conviction that the court had in saying is that the appellant, by her decisions previously, had basically terminated her own parental rights, and I'm going to do something about that. I'm going to give her a standard visitation schedule, and that standard visitation schedule is what she seems to be complaining about. But if the court just stopped the case as it could have, she would have reverted back to either no visitation or supervised visitation under the Pendini Lati order.
Thank you.
Okay. Thank you.
I believe you have 5 minutes.
Thank you, Your Honors. Your Honor, I'll begin by saying we are in agreement that there was an order entered, which is why I had that befuddled look when Your Honor initially asked me about it. So where I was going before in regards to Rule 60, which may not be the most fertile ground for me to plow here, but I'm going to go this direction. Whether the trial court should have limited the appellant's trial counsel in going forward on particular aspects of Rule 60, be it mistake or fraud or extraordinary relief, no such limitation was put on that, nor was there any discussion as to that limitation. Your Honors have seized on what I felt like was one of the most important issues, is clearly from the record, everything that occurred through the course of the case, the discussions during the actual hearing itself, the initial order from the December 20 hearing, or the initial announcement at a minimum, was based upon this drug screen that was administered by the court. And Mr. Unwood is correct that the court orders them to be administered. They are administered there in the courthouse by court staff, which is somewhat different as well, especially in the lens of an order of protection. But that occurred, and I would argue that the steps that were taken from what was called the free and calculated choice of the appellant, the steps that were taken were to immediately go out and get these drug screens to try to demonstrate that the one administered by the court was in fact false.
So the court administers the drug screen, or the juvenile court? I assume that's what we're talking about.
I believe that is our collective understanding, Your Honors.
So if you challenge the drug screen that the trial court administered, are you asking the court to determine its own credibility?
I'm afraid you are, Your Honor.
Sounds a little problematic.
I believe that it is, Your Honor. And that's why she went out and she got those screens and she tried to demonstrate that I am in fact free of drugs, therefore the test administered by the court was faulty or mistaken under 60.02 Part 1.
Did the new drug screens test for everything that was tested for when she was in court on December 20th?
To my recollection, yes, Your Honor, I believe so. And there was a considerable amount of testimony from the person who administered those screens and the processes that he went through to ensure that they were collected properly, the chain of custody to the lab to ensure that they weren't adulterated in some way, as was insinuated by Appellee's counsel. And that's my argument, Your Honor.
Okay, thank you. Thank you, gentlemen. We will take this matter under advisement and endeavor to get you an opinion at the earliest possible time. We appreciate your argument and your briefing. You may be excused.